Right. So you've probably seen that those Just Stop Oil people got sentenced to, well, the ringleader, Mr. Hallam, got 5 years, and the rest of his merry gang got 4 years. But now some self-proclaimed cultural icons, 1,200 of them, have written a letter to the new Attorney General demanding a meeting to discuss these sentences and how terrible they are. And they want it all filmed and all this sort of thing. So what's going on here? Well, first of all, just in case you're not familiar with the background to this, a bunch of Just Stop Oil people, they had a Zoom meeting to plan some disruptive protests, to close down the M25 effectively. I mean, they could have just let, highways agency do it, with some road works, but they decided to do it themselves. So they had a Zoom meeting, and a reporter from The Sun logged on because it was open to the public, and they just planned all these disruptions, and she reported them to the police. And they were prosecuted for conspiracy to commit public nuisance. Now, there'd been a new law that said if you interfere with national infrastructure, or you plot to interfere with national infrastructure, then the sentencing is really, really high now. So they were duly convicted. They went to court, they represented themselves. Now, contrary to what you've seen, where they say, oh, they weren't allowed to defend themselves, they weren't allowed to put a defence up, the judge actually gave them, a lot of leeway. The prosecution, they did what we call agreed facts, admissions. They said, yeah, we accept, climate change is a big problem. They weren't under any obligation to do that, but they said, yeah, it is. However, we say what they were planning to do, notwithstanding, why they were doing it, they went too far. Now, some people, you've seen this as advertised as, oh, well, they've been sent to prison just for having a Zoom call, which I don't normally give my opinions here, but I think that's a bit silly because that guy who got a life sentence for plotting to kidnap Holly Willoughby, I mean, technically, that's like saying somebody got a life sentence just for having an internet chat with people. But it's like, yeah, they planned to kidnap somebody. But they were done for conspiracy. Now, the thing with a conspiracy is you don't actually have to commit any further offences. The element of conspiracy is you just agree to commit a crime with people. You don't have to carry it out. It's the agreement is, as soon as you've agreed to do something, and you can either verbally agree it, or there is a nice case that says you can commit a conspiracy with a nod and a wink. But also, some people actually did carry out this. And in the sentencing remarks, the judge points out people missed job appointments, people missed hospital appointments, people were late for school, deliveries of food to hospital were disrupted, there were accidents caused by, the roads being blocked. And I think where it crossed the line for me was somebody who's got a really aggressive form of cancer missed their treatment and they can't reschedule it. They couldn't reschedule it for 2 months. So the judge said, look, you have crossed the line from being sort of activists into being fanatics. And, he handed out sentences that are very much in accordance with the new sentencing guidelines for these offences. Basically, I said, I don't accept that you will go away quietly, because Roger Hallam said, okay, I've learnt my lesson now, I'll be really good from now on. But then within the trial himself, he spoke for 3 hours just ranting on about, all sorts of nonsense. I mean, don't get me wrong, I am your typical SJW woke person. I am a, very eco-friendly animal rights activist myself. And one of the reasons I find this personally annoying is I think they ruin it for the rest of us. I also find a lot of Just Stop Oil people, they're not really environmentalists, just to go on a little rant here. Because one of the second biggest cause of climate change is animal agriculture. And while they'll shut down Glyndebourne and, football matches and things that people enjoy, they all go to Glastonbury. And Glastonbury, the Eavis family are quite happy to say Glastonbury just subsidises their cattle farming business, and cattle farming is a massive source of emissions for climate change. So personally, I am not convinced these people are doing it for the right reasons. And also there's the whole thing that, some people say, oh, well, this is good because it raises awareness. It actually puts people off the cause. So I am very unsympathetic, it has to be said. But anyway, so they have been duly sentenced, and no doubt they will lodge appeals against those. But is there anything in this asking to see the Attorney General? Well, actually, no. I mean, what's weird is some lawyers have signed this letter, and they should know better than anybody. The Attorney General has no input on this. You know, they said, oh, Keir Starmer should intervene. Well, the whole point of having an independent judiciary and legal system is politicians can't say either let this person off or prosecute this person. You know, the legislators pass the laws, but it's for the judges to interpret the laws and pass sentences accordingly. Now, the only role the Attorney General has is if he finds a sentence is unduly lenient, he can refer it to the Court of Appeal and say, I think this sentence is unduly lenient, not just lenient, it has to be like ridiculously lenient. Maybe you should have a rethink about this. But who should you approach if you think a sentence is too long? Well, that's the defence's job to put in the appeal. The Attorney General has no say in saying, I think this sentence is a little bit high. So is it going to go anywhere? Well, clearly not. I don't think. I mean, this new Attorney General is a really nice guy. Ironically, he used to do, when he was a barrister, he brought loads of cases against the government. That was kind of his forte. He's very much poacher turned gamekeeper. So personally, one of my predictions, he's not going to have the meeting. And this is going absolutely nowhere. Like I say, the defence can appeal if they want. They first of all have to get permission to appeal by saying, first of all, if they appeal the conviction, it'd have to be the judge got something manifestly wrong in the trial. And despite people saying they weren't allowed to present their defence, they just wasted the opportunity. They didn't actually run any sort of like standard defences. They just went on about, climate change generally. Now, interestingly, there is a defence to public nuisance, which is your actions were reasonable. So yes, you committed a nuisance, but actually you had a good reason to do it. Although when you're charged with conspiracy, you can't actually run the I had a reasonable excuse for doing it. But I personally can't see anything within the trial itself. I think the judge actually bent over backwards, but effectively gave them enough rope to hang themselves. I just don't think it goes down very well. And like I say, when people are missing appointments, when people with cancer are missing appointments because they've been blocked, I can see why the jury actually convicted, and I can see why the judge did such high sentences. The judge actually said, had you have actually got away with your plan, which was to gridlock the M25, you'd be getting 10 years. So consider yourselves lucky that you only got the 5 because the disruption wasn't actually that bad. But what's interesting is there's another case at the moment about all this protest. Now, I did a video ages ago, which I won't bother linking to, I'll just tell you. This was all to do with sort of the Public Order Act and disruption there. And the offence used to be that it was an offence to commit serious disruption, okay? But the government passed some like what called secondary legislation. So it was just a minister signing off on this. It wasn't voted on in Parliament, saying, actually, we define serious disruption as anything that is more than minor disruption. And Liberty actually challenged that and said, well, first of all, you don't have the power to make this secondary legislation, and also, even if you did, you've just got it wrong. And what's interesting is, the first instance court agreed with Liberty and said, yes, first of all, the minister didn't have the power to do this, and also we're sort of on board with the idea that this is actually not proportionate. Now, that was appealed by the government, actually. But what's interesting is the new government have said, you know what, we actually think, we agree. We agree. If we want to change the law like this, then it should all go through Parliament and be properly voted on. So Liberty have agreed to hang fire on that appeal. It's been stayed, and it wouldn't surprise me here. And another prediction, the government will throw the towel in and will actually withdraw from this appeal. So we'll go back to the idea that it has to be serious disruption. So If you just basically block a road for 5 minutes and it's no worse than being in a traffic jam, that's, perhaps more than minor, but it's not serious disruption. So I think we'll go back to what the old law was on that. And also, the people who vandalised that painting by throwing the orange paint on it, that trial starts. Now, again, I am very much into my art. I do like my art. And I know they're saying, oh, well, it's behind glass, it didn't cause any harm. Well, first of all, it does. I've got a lot of friends who do like conservation of paintings and things like that. And old paintings, especially like Van Gogh's and things like that and Rembrandt's, even the tiniest molecule of the wrong substance can actually damage those paintings permanently. Old hundreds of year old paintings are very, very vulnerable. Also, they trash the frame. The frame, that can never be used again. So that has been permanently damaged. And the other thing is, it just leads to the fact that you just end up with paintings going behind glass. And paintings aren't designed to go behind glass. They're designed to be looked at, and you get barriers up and all sorts of things. So, it's the knock-on effect of it will just make it harder and harder for people to actually enjoy these paintings because the security will end up being so high. They'll all be put behind glass like the Mona Lisa. They'll put them behind barriers so you can't get up close and see the brushstrokes. And, a lot of paintings, you need to have your nose up against the painting to actually see it and things. And also, as I keep pointing out, actually, the destruction of art, or cultural heritage, as we call it now. We used to call it cultural property, but people said, well, no, because not all cultures have the same idea of property as we do. If you were to trash Uluru, Ayers Rock, if you were to say to your average Aboriginal, who owns Ayers Rock? Well, officially, it's owned partly between the government and partly between the Aboriginal tribes. But actually, they'd say, well, nobody owns it. It's been there forever. How can you own a rock? So that's why we say cultural heritage, not cultural property. But it is actually a war crime. Remember all the old monuments thing, after the war, where they went around trying to get all the paintings back. And I've done another video about the symbol, because, I did all my sort of Red Cross, Red Crescent, Magdan David, all the protected symbols that say this is off limits. There's actually a specific one. There's like a blue sign that you can put up on important like historical buildings. If the building itself is significant, or if it's a museum or an art gallery, you can put this up, and that means it's off limits as long as you don't actually use it, for military purposes. So we do take these sorts of things very, very seriously. But that trial starts. But what's really interesting about that trial is it's the same judge who's just sent all these guys down for like the 5 years and the 4 years. So it'll be very interesting to see what happens there. So yeah, this is an unusual one for me because I'm sort of going on to my sort of, personal views a little bit. Because like I say, I think the actual cause is a legitimate one, but I just get very frustrated with these people because I think they ruin it, they actually ruin the argument and they make it harder to argue. But all these 1,200, I mean, the fact that you've identified, said, we are cultural icons. I mean, that's a bit pretentious, really, isn't it? And it's clear a lot of them don't actually understand what has gone on. But like I say, I don't think anything's coming of that. I mean, I'm all for direct action. There's a case coming up that a lot of new law coming in, and actually, it's pet abduction, because it basically, if you nick somebody's cat or dog, then yes, that's just considered theft at the moment. But what if you just induce a dog to follow you or a cat to follow you? Technically, you're not committing any offence. Well, now you are. So pet abduction is now an offence. But what I'm slightly concerned about is I bet the first people this gets used against won't be somebody who actually nicks a dog. It'll be people rescuing beagles from, laboratories and things like that. I mean, I'm not sure how far I should discuss this, but I get some very strange phone calls from some of my animal rights friends. It's like, can you look after some... I remember once somebody said, can you look after some pigs for a bit? It's like, well, how many of them? 72. No. So, and then later go, actually, it's not 72, it's 128. Well, yeah, still no. I mean, I feel sorry for these pigs, but I cannot accommodate that many pigs. But I must confess, I nearly ended up with some beagles from a lab once. And we had to run a very interesting argument to not give them back to the laboratory. Because if you find an animal and return it, the police have to give it back to the original owners, unless it is being used for the purposes of vivisection. And I'll talk about this because the law, they clearly got it wrong. Because they say notwithstanding anything in this section, and they clearly meant notwithstanding anything in this subsection. So we're able to argue and say, well, look, clearly Parliament didn't mean to say that, but it's not the court's job to correct their sloppy drafting. It didn't actually get that far, and in the end, actually, the police said, all right, keep the dogs. So like I say, it's not like I am against direct action, but I just think it should be aimed appropriately. So, I'm all for my animal rights friends sort of rescuing animals that are being vivisected and things like that. And I'm all for people disrupting illegal hunts. But I just think when you get to this stage, it just goes too far, because what had that painting done to anybody? What had people trying to get to hospital appointments done to anybody? You're targeting the wrong people. But there you go. It'll be interesting to see the comments on this one, because I've probably alienated everybody, because I'll have alienated all the all my eco friends by saying no, I think they should be banged up for even longer, and I'll probably annoy everybody else for sort of saying, actually, no, I am all for breaking the law when it's appropriate. But anyway,
Daniel J. Shen Smith.
that's Dan the Black Belt Barrister calling me in the middle of a video. I'm actually going to say it on time. Dan, you're going to be in one of my videos, because I'm literally filming it now. But can I call you back later? Okay, speak to you soon. And no doubt Dan would have actually reminded me and said, don't forget to tell them, if you did like it and find it vaguely useful and vaguely interesting and vaguely whatever, vaguely controversial, don't forget to like and subscribe. And I'm actually filming this on a really nice camera that Dan bought me. So thank you, Dan. Assuming I've pressed the right buttons and set it up correctly. Did I say like and subscribe? Yeah, I did. Oh, where am I today? I'm just back at Frogpool, because it's that pub I like.